Good morning, everyone. I see all of you guys filtering in. Welcome. This is a presentation put on by ACE, Association Community Education, by TSK Marketing. We have a great presentation today that we will introduce Danielle Brennan in just a moment. I want to make sure that we thank our sponsors for presenting this amazing series, making this possible for us to do this great series of webinars. That's A1 Appliance, that's Association Reserves, Hotwire, KBR, Plastridge Insurance, Regal Paint Center, and WRG. Thank you, Jeff. And thanks to Jeff for running all the behind the scenes tech this morning. We really appreciate it. So with that, Danielle, please introduce yourself, your course, and take it away.
Good morning, everyone. Thank you so much for joining us on this lovely Tuesday morning. As she said, Marielle said, my name is Danielle Brennan. I'm an attorney here with Kaye Bender Rembaum. I am in our Palm Beach Gardens location, though we do have other locations throughout the state of Florida, including Pompano Beach in Broward County, Tampa, Orlando, and in Miami-Dade County by appointment. I do apologize. You heard I just cleared my throat. I am under the weather today. So apologies for my voice and if I have to cough during the presentation. We are 21 attorneys at Kaye Bender Rembaum. 10 of us are board certified, 9 of which are in condominium and plan development law, 1 in construction law. I am one of the 9 board certified in condominium and plan development law attorneys. This is what we do every single day. We provide representation to community associations throughout the state of Florida, and we are experts in this field. So if you guys are looking for a new or an additional community association attorney for your association, we would love for you to consider Kaye Bender Rembaum. So before I jump into the presentation, I just want to let you know that this is an informational educational seminar. This is not legal advice. So if you're looking for some legal advice, the best person to go to is, you guessed it, your association's attorney. Okay, so let me share my screen. We're going to dive right in because I do want to get to answer some of your questions. Okay, so here we go. Let me see how I can do this from beginning. From beginning, let's try that again. Okay, here we go. So the course is called Navigating the Federal Fair Housing Act, Assistance Animal or Pet. We do have a 2-hour course that is just Fair Housing Act in the more general sense, but this today is hyper-focused on assistance animals, including both service animals and support animals. And let's get to it. So it's the policy of the United States to provide within constitutional limitations for fair housing throughout the United States. Both the Department of Justice, the DOJ, and the Department of Housing and Urban Development, HUD, are responsible for enforcing the Federal Fair Housing Act. The Fair Housing Act at a federal level prohibits discrimination in housing on the basis of race, color, religion, sex, national origin, familial status, which is essentially age, and disability. When it comes to assistance animals, our focus, our protected class focus is disability. Just to note that there are state and local ordinances too that come into play when we were talking about fair housing for the state of Florida. Our fair housing laws are set forth in Part 2 of Chapter 760, which is our Civil Rights Act. Excuse me. And the administrative agency that enforces the Fair Housing Act for Florida is the Florida Commission on Human Relations here in Palm Beach County. We also have additional protected classes: sexual orientation, age, marital status, gender identity or expression, and the administrative agency which enforces the fair housing laws here is the Office of Equal Opportunity. So at the federal level, we have the U.S. Code. That is all of the statutes that are enacted by Congress. They contain enabling legislation which allow for the administration administrative adoption of the Code of Federal Regulations. Similar here in Florida, where we have our Florida statutes, and then Florida statutes has enabling legislation for different administrative agencies like the Department of Business and Professional Regulation in our division of Florida condominiums, timeshares, and mobile homes under the Florida Administrative Code, which is where they adopt all of their rules. And it's similar even on our micro level in our associations, where we have our declaration, which is kind of like our statutes, and our rules and regulations, which are adopted administratively by the board. This shows you just a small breakdown of what is set forth in the Code of Federal Regulations when it comes to the Fair Housing Act. The Fair Housing Act prohibits housing providers from discriminating against housing applicants or residents because of their disability. Like I said, we're really focused in on disability for today's presentation, notwithstanding that there are other protected classes under the Fair Housing Act, or the disability of anyone associated with them. The Fair Housing Act prohibits treating persons with disabilities less favorably than others and makes it unlawful for any person to refuse to permit, at the expense of the disabled person, reasonable modifications of existing premises or to be occupied by such person if such modifications may be necessary to afford such person full enjoyment of the premises. There are reasonable modification requirements under the Fair Housing Act. That's not the focus of today's presentation. We're really focusing on reasonable accommodations, and the Fair Housing Act makes it unlawful for any person to refuse to make reasonable accommodations in rules, policies, practices, or services when such accommodations may be necessary to afford persons with disability equal opportunity to use and enjoy a dwelling. And as you guessed it, those rules and policies, practices are either no pets or certain pet restrictions, pet prohibitions that might be set forth in your association's governing documents. There are certain exemptions from the application of the Fair Housing Act for religious organizations, private clubs, certain familial status exemptions if you're housing for older persons. The Fair Housing Act does not prohibit conduct against a person because such person has been convicted by any court of competent jurisdiction of the illegal manufacture or distribution of a controlled substance. And the Fair Housing Act doesn't apply to certain real estate transactions. Now, a lot of times when we hear about the Fair Housing Act, we also will hear about the Americans with Disabilities Act. And they're different laws, but there is a lot of interplay. The ADA prohibits discrimination based on disability. So does the Fair Housing Act, although like we discussed earlier, the Fair Housing Act also prohibits discrimination on the basis of other protected classes. The ADA applies to employment, government, public accommodations, commercial facilities, transportation, and telecommunications. Whereas Fair Housing Act applies to private housing, federal assistance, housing that receives federal assistance, and state and local government housing. But there is an interplay for both, where there are public accommodations within private residential communities. Both provide for animals to assist the disabled. However, ADA only provides for service dogs and on occasion the miniature horse, which has particular training. And animals under the Fair Housing Act can be any type of animal, including unique animals, which we'll discuss a little bit later. And there's no specific training that's required under the Fair Housing Act. One uses the term disabled, ADA uses the term disabled, FFHA uses the term handicap, but a rose by any other name would still smell as sweet. It's basically the same thing. They have the same functional definitions as this slide says right here. So what does the term handicap mean? There are three definitions provided. However, the first definition is the one that's most widely used and referred to. The term handicap means, with respect to a person, a physical or mental impairment which substantially limits one or more major life activities, a record of such impairment, or being regarded as having such impairment. The term handicap does not include current illegal use of or addiction to a controlled substance. But as you know, you may have heard of the term sober homes. People recovering from substance abuse would be covered. Physical or mental impairment includes any psychological disorder and condition, cosmetic disfigurement, musculoskeletal condition, mental or psychological disorder. All these different types of things would constitute a mental or physical impairment. A major life activity means functions such as caring for oneself, performing annual tasks, walking, seeing, and certainly this list is not exhaustive. Having a record of such impairment means a history or record of or has been classified as having a mental or physical impairment that substantially limits one or more major life activities, and is regarded as having an impairment means has a physical or mental impairment that does not substantially limit one or more major life activities, but that is treated by another person as constituting such a limitation, or has a physical or mental impairment that substantially limits one or more major life activities only as a result of the attitudes of others towards such impairment, or has none of the impairments defined in paragraph A of this definition, meaning one, I apologize for that, but is treated by another person as having such impairment. So based on this last bit of definition here, be careful who you call crazy, right? It is unlawful for an association to ask if an applicant for a dwelling has a disability, or if a person intending to reside in a dwelling or anyone associated with an applicant or resident has a disability, or about the nature or severity of a person's disability. Like we touched on earlier, under the Fair Housing Act, the housing provider would be required to provide a reasonable accommodation or reasonable modification if there's a disability and disability-related need. There are differences between the two, although they may be coupled. Under the Fair Housing Act, a reasonable accommodation is a change, exception, or adjustment to a rule, policy, practice, or service. And under the Fair Housing Act, a reasonable modification is a structural change made to the premises. A person with a disability may need either a reasonable accommodation or reasonable modification, or both, in order to have an equal opportunity to use and enjoy a dwelling, including public and common use spaces. So as we touched on before, this is just a regurgitation. It's unlawful for any person to refuse to make reasonable accommodations in the rules, policies, practices, or services when such accommodations may be necessary to afford a handicapped person with equal opportunity to use and enjoy a dwelling unit, including public and common use areas. As to assistance animals, requests are made for reasonable accommodation to an association's pet restrictions so that a disabled person may have an assistance animal within their community or condominium. Could be, a prohibition as well. So association procedures. The association is not required to adopt any formal procedures. However, having formal procedures can aid the disabled person in making their reasonable accommodation requests and can aid the association in assessing those requests, and in the event of a dispute can provide records to show that the requests received proper consideration. So it's advisable to have it, though you can't force a person who is wanting a reasonable accommodation to any pet prohibition or restriction to actually fill it out and complete it. The association may make the truth and accuracy of information provided during the process part of the representations made by an applicant. And we would, obviously, if you're going through the practice of preparing procedures and adopting them, would advise you to make the truth and accuracy of that information a condition of that application. I know that this is the Federal Fair Housing Act, but I wanted to just mention in the state of Florida, there are certain criminal penalties for providing false information or false documentation to support a request for a support animal or a service animal. Like I said before, a housing provider cannot refuse a request because the individual making the request did not follow any formal procedures that the provider has adopted. So long as the housing provider could reasonably understand that a request for a reasonable accommodation is being made, you have to operate that way. They don't have to use any magic words like reasonable accommodation. It doesn't have to be in writing. It can be oral. The request can be made at any time, even after the resident has brought the animal into the community. Just if you see an animal and you have a reason to believe, or the person has made a request and the request can be reasonably believed to be a request for an accommodation under the Fair Housing Act, treat it that way. So under the recent guidance from HUD, which was issued in January of 2020, it really changed the way that we look at our assistance animal requests when it comes to service animals versus support animals. So service animal is an ADA type animal. We'll get more into that in the next slide. Just know that there are two different types of animals and we have to look at them very differently. Okay, so first we see, is the animal a service animal? Under the ADA, a service animal is narrowly defined as any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability, including a physical, sensory, psychiatric, intellectual, or other mental disability like a PTSD. Performing work or tasks means that the dog is trained to take a specific action when needed to assist the person with a disability. Other species of animals, whether domestic, wild, trained, untrained, they're not service animals for the purposes of the Fair Housing Act. It's got to be a dog. Excuse me. The work or tasks performed by a service animal have to be directly related to the individual's disability. There's got to be a nexus there. Emotional support, comfort, well-being, and companionship are not deemed work or tasks for the purposes of a service animal. So if a person is saying that I have a service animal because of their depression, which substantially limits their ability to work, that's not necessarily a service animal. However, that could be a support animal covered by the Fair Housing Act, which we will discuss after we discuss service animals. So first we have to determine if the request is for a service animal. First question, is the animal a dog? If not, then the animal's not a service animal, but it could be a support animal. If so, well, then we have to ask, is it readily apparent that the dog is trained to do work or perform tasks for the benefit of an individual with a disability? If yes, then we can't ask any more questions. And if we do ask questions, well, then we might be in violation of the fair housing laws for asking for information which the association is not entitled to. So we need to be very careful when we're asking for additional information. It is readily apparent when a dog is observed guiding an individual who is blind or has low vision, pulling a wheelchair, providing assistance with stability or balance to an individual with an observable mobility disability. Obviously, those are going to be the most observable disabilities when it comes to a service animal and whether or not they have the training. Is the animal required because of a disability? Yes, and the work or task is identified. Then you need to grant the request if otherwise reasonable, because the animal is a service animal for the purposes of the Fair Housing Act. If not, the animal is not a service animal, but could be a support animal. If at least one action the dog is trained to take is helpful to the disability, the dog should be considered a service animal. If no specific action is identified, the dog should not be considered a service animal, but could be a support animal. If an animal is not a service animal, it may still be entitled to access if it is considered a support animal. A support animal is trained or untrained animal, doesn't necessarily have to be a dog, that does work, performs tasks, provides assistance, and or provides therapeutic emotional support for a disabled person. Again, not required to be a dog, can be any animal commonly kept in households or a unique animal that's not commonly kept in households, but that having that unique animal has certain requirements, which we'll touch on later. Establishing the disability. Does the person have an observable disability, or does the association already have information giving them reason to believe the person is disabled? If yes, we can proceed to the next question, which is establishing the disability related need. Because remember, I mentioned earlier, if the person is disabled, has a disability related need. It's really a two-pronged question, right? If not, then we can move on to asking for additional information regarding the disability, which we'll touch on in the next slide. Observable disabilities include blindness or low vision, deafness or being hard of hearing, mobility limitations, and other types of impairments, neurological impairments, mental illness, or other diseases or conditions that affect major life activities or bodily functions. So next question, has the person requesting the accommodation provided information that reasonably supports that the person has a disability? If not, the association is not required to grant the accommodation, but the association has to provide the person requesting the accommodation with a reasonable opportunity to provide information that reasonably supports the person has a disability. Information about disability can include a determination of disability from a federal, state, or local government agency, receipt of disability benefits, Medicare or supplemental security income for a person under the age of 80 or 65, veterans disability benefits, eligibility for housing assistance or housing voucher received because of a disability, information confirming disability from a healthcare professional like a physician, optometrist, psychiatrist, psychologist, physician's assistant, nurse practitioner, or nurse. A determination that a person does not qualify as having a disability for purposes of a benefit or other program does not necessarily mean that the individual does not have a disability for the purposes of the Fair Housing Act or the Americans with Disabilities Act. Some types of impairments will, in virtually all cases, be found to impose a substantial limitation on major life activity, resulting in a determination of a disability. These include deafness, blindness, requiring a wheelchair, cerebral palsy, diabetes, cancer, MS, HIV, bipolar disorder. When you see these types of impairments, just know that in virtually all cases, they will be found to be a disability. Establishing a disability-related need. Has the person requesting the accommodation provided information which reasonably supports that the animal does work, performs tasks, provides assistance, and/or provides therapeutic emotional support with respect to the individual's disability? If not, the association is not required to grant the accommodation, but again, the association has to provide the person requesting the accommodation with a reasonable opportunity to provide information that reasonably supports the animal does work, performs tasks, provides assistance, and/or provides therapeutic emotional support with respect to the individual's disability. So what kind of documentation are we talking about here? Reasonably supporting information often consists of information from a licensed healthcare professional. Again, the list: physician, optometrist, psychiatrist, psychologist, physician's assistant, nurse practitioner, or nurse. It's general to the condition, but specific as to the individual and the assistance or emotional support provided by the animal. A relationship or connection, oftentimes you'll hear the word nexus, between the disability and the need for the assistance animal has to be provided, particularly where the disability is not observable or the animal provides emotional support. For non-observable disabilities and animals that provide emotional support, the housing provider can ask for information that is necessary to conduct an individualized assessment of whether it must provide an accommodation. The lack of such documentation in many cases can be reasonable grounds for denying a requested accommodation. But again, you still need to provide a reasonable opportunity for the applicant to provide such information. HUD encourages housing providers to direct requesters to the guidance on documenting an individual's need for assistance animals in housings to help the requester understand what information is being sought and to ensure that the housing provider gets the information it needs. This guidance on documenting an individual's need for assistance animals in housing is part of the January 2020 guidance that was issued by HUD. So internet documentation, I can't tell you how many times that we have seen different certificates or registrations, if it's a United Registry of Assistance Animals or what have you, emotional support animals, the number of times that we get that information. It's very nice and someone has made money off of you for that, but it's not something that in and of itself will substantiate a person's request for a reasonable accommodation under the Fair Housing Act for an assistance animal.
Danielle, is that like, sorry, is that like the stuff you can, like anybody could just go on Amazon and get? Is that what you're referring to?
So yeah, basically, I mean, if you could go on a website on Google and look for emotional support certificate,
Yeah.
you input a little bit of information and it generates a certificate and a number, and you provide that number to your association, and it's you can look at, they'll say things like, oh, this is verifiable.
Yeah.
If you go onto our website and verifies that you are registered, but it doesn't provide any other additional information.
Yeah.
That alone is not going to substantiate a person's request for a reasonable accommodation under the Fair Housing Act. So, it's nice. It's nice for them to provide, but it's not everything.
It's not everything. I just wanted to clarify. Thanks for that. And sorry for the interruption.
No problem. So, like I said, somebody's making $1 off of you for that. Don't be fooled or suckered by it. In HUD's experience, such documentation is not by itself sufficient to establish that a person has a disability or disability-related need for an assistance animal. However, many legitimate licensed healthcare professionals deliver services remotely, including over the internet. And especially in post-COVID times where telehealth is becoming more prevalent, this is also becoming more prevalent. And I know in Florida, again, we're talking about the federal laws here, but in Florida, we do have a particular law that discusses telehealth providers and out-of-state providers. Telehealth providers can be licensed doctors in another state, but licensed telehealth here in Florida. So if they're in another state, they're licensed here to provide telehealth. A person sitting in Florida can have a telehealth visit with someone who's licensed in a different state and have that still qualify. If they're not licensed telehealth, I'm certainly no expert on professional regulations affecting medical service providers, but I think that if you are a doctor in another state, licensed in another state, but you're not telehealth here in Florida, you would have had to see that doctor in person in order for that to count toward or substantiate a request under the Fair Housing Act for a reasonable accommodation. Let's see here. Let me get back on track. One reliable form of documentation is a note from a person's healthcare provider that confirms the person's disability and or need for an animal when the provider has personal knowledge of the individual. Now, there's no great definition for what's provided of personal knowledge. Well, how many times does that person have to be seen? How long does the visit have to be? There's no great guidance on that. And certainly when it comes to questioning someone's documentation on that basis, talk to your association's lawyer, get their guidance there. And I would be very hesitant to tell any of my clients to say, well, they've only seen this person however many times. Let's, go ahead and turn them down. Always engage in that interactive process. Ask for additional information if it's warranted. And a lot of times you won't even know the length of time or how many visits a person has had with a healthcare provider based on the information that's provided to you. Official records. So documents provided to the association regarding a request for a reasonable accommodation are maintained among the official records of the association. However, they're not accessible to members because the members cannot inspect certain official records of the association, including information obtained in connection with the approval of a lease, sale, or other transfer of a parcel. If you have maybe like on your governing documents an approval process, medical records of unit owners, parcel owners, or HOA community residents, social security numbers, driver's license numbers, and other personal identifying information of any person. So notwithstanding that these documents will be official records of the association, they're not accessible to the members. So we were talking before about the different types of animals. For a service animal, it has to be a dog. For a support animal, it's a common household animal and possibly a unique animal under certain circumstances. So let's dive into that a little bit. Is the animal commonly kept in households? If yes, the request should be granted unless an exception exists. If not, the association is not required to grant the accommodation except in rare circumstances. If the individual is requesting to keep a unique animal, then the requester has the substantial burden of demonstrating a disability-related therapeutic need for the specific animal or the specific type of animal. The individual is encouraged to submit documentation from a healthcare professional confirming the need for this type of animal. For example, that allergies prevent the person from using a dog, or without the animal, the symptoms or effects of the person's disability will be significantly increased. There is an example that HUD provides. An individually trained monkey performs tasks for a person with paralysis caused by spinal cord injury. The monkey has been trained to retrieve a bottle of water from the refrigerator, unscrew the cap, insert a straw, and place the bottle in a holder so the individual can drink and can switch lights on and off and retrieve requested items from inside cabinets. The unique animal is permitted because the monkey can use its hands to perform manual tasks that a dog cannot perform. An animal that poses a direct threat. So a housing provider is not required to provide a reasonable accommodation where the animal poses a direct threat that cannot be eliminated or reduced to an acceptable level through actions the individual takes to maintain or control the animal, like keeping the animal in a secure enclosure. A determination that an assistance animal poses a direct threat of harm to others must be based on an individualized assessment that relies on objective evidence about the specific animal's conduct, not on mere speculation or fear of types of harm or damage an animal may cause, and not on evidence about harm or damage that other animals have caused. We see this particularly when it comes to specific breeds of dogs, namely pit bulls. When a request for a support animal comes in for a pit bull, a lot of times people will be like, oh no, pit bulls, they're a dangerous breed, what have you. But having family members and friends who have pit bulls, it really is dependent on how they're raised, and it's certainly not breed specific. And those breed restrictions would not apply in the context of an assistance animal. An association cannot deny the request for an assistance animal because the board is uncertain whether or not the person seeking the accommodation has a disability or disability-related need for an assistance animal. Before denying a reasonable accommodation request due to lack of information, the housing provider is encouraged to engage in a good faith dialogue with the requester, called the interactive process. I know you've heard me say it already during this presentation. The housing provider may not insist on specific types of evidence if the information which is provided or actually known to the housing provider meets the minimum requirements of the Fair Housing Act. Disclosure of details about the diagnosis or severity of a person's disability or medical records or medical examination cannot be required. So recall that earlier I said you can request documentation if it's reasonable to do so. You really need to take a look at what documentation has been provided, provide an individualized assessment, and determine if it's reasonable under the circumstances. There is really no one size fits all when it comes to evaluating requests for assistance animals under the Fair Housing Act, and it has to be done on a case-by-case basis. If refused, then you must consider alternative accommodations. When a housing provider lawfully refuses a requested accommodation because it's not reasonable, the housing provider should discuss with the requesting party whether there's an alternative accommodation that would effectively address the requester's disability-related needs without a fundamental alteration to the provider's operations and without imposing an undue financial and administrative burden. Sometimes when people hear about the fundamental alteration of the provider's operations, boards will say, well, our community is a no pet community, and requiring us to have assistance animals within our no pet community is a fundamental alteration to our operations. That's not the case. Sorry. If an alternative accommodation would effectively meet the requester's disability related needs and is reasonable, the housing provider must grant it. Associations cannot require applicants and residents to pay a deposit for an assistance animal or to pay any extra fees as a condition of receiving a reasonable accommodation, even if the deposit or fee is charged for pets. An assistance animal also cannot ask an applicant to provide access to medical records or medical providers or provide detailed or extensive information or documentation of a person's physical or mental impairments. Again, you're not entitled to know, the association is not entitled to know the nature or severity of a person's disability. And it's also the requirement of the person who's requesting the accommodation to provide such documentation. An association cannot unreasonably deny a response to a reasonable accommodation request. An undue delay in responding may be deemed a failure to provide a reasonable accommodation. And in accordance with the latest guidance issued by HUD, again in January of 2020, the best practice there is 10 days. So you have to have a pretty quick turnaround when it comes to assistance animal requests. I know that when we receive them, as soon as I get it, it moves to the top of the list. Where can assistance animal go? A disabled person is responsible for feeding, maintaining, providing veterinary care, and controlling the assistance animal. The individual can do this on their own or with the assistance of family, friends, volunteers, or service providers. And the association must modify or provide an exception to its no pets rule or policy to permit a person with a disability to live with and use an assistance animal in all areas of the premises where persons are normally allowed to go, unless doing so would impose an undue financial and administrative burden or would fundamentally alter the nature of the housing provider's services. A lot of times you'll see this in like a housing development where they have like a restaurant or something or bistro inside. There's not much to go on under the Fair Housing Act in that particular regard as to where the animal can go. But under ADA, we do have some guidance about the animal not going into the food preparation areas, excuse me, or being allowed to sit at the table and being entitled to, not being entitled to the use of food and drink, which are reserved for people. Excuse me. So rules governing the conduct of assistance animals. Conditions and restrictions that apply to pets may not be applied to assistance animals, such as weight, breed, or size restrictions. Given a board's authority to promulgate rules, reasonable rules and regulation, a board has limited ability to adopt rules and regulations applicable to service animals. However, it's really unclear as to which particular rules would be deemed reasonable when it comes to assistance animals. And the association needs to be aware that whatever rules that it may adopt, you may have to provide accommodations to those rules, such as rules requiring owners of assistance animals to pick up the animal's waste. There may be an issue if that person can't do that, is physically unable to do so. So again, consult your association's lawyer and get their opinion on the adoption of those types of rules. Effect on pets. An assistance animal does not count toward the number of allowable pets. If your association has a rule that says no more than 2 pets per unit or 2 pets per home, it's not going to count toward that. So a person can essentially have 2 pets and an assistance animal. Violations of the Fair Housing Act. So a plaintiff can establish a claim under 3 separate theories: intentional discrimination, disparate impact, and failure to allow a reasonable accommodation or modification. There are different venues to bring a complaint. The most common, I think, is the administrative agency for an administrative determination for fair housing laws that exist at federal and state levels, and that may exist at a local level. An aggrieved party can file a complaint with each for a violation of each level's fair housing laws. Again, at the federal level, you have the DOJ and HUD. HUD can refer it to a state or local agency. Here in Florida, we have the Florida Commission on Human Relations. And again, in Palm Beach County, we have the Office of Equal Opportunity. The complaint can be filed in court for judicial determination. The aggrieved party does not have to seek relief from an administrative agency prior to filing a lawsuit in court. A complaint that has been brought to HUD may still be taken to court so long as a conciliation agreement has not been entered into and an administrative law judge has not started a hearing. Once those things have happened, it really needs to be carried through that process. The division, this is Division of Florida Condominiums, Timeshares, and Mobile Homes. They will not hear fair housing violation claims. The claimant will be instructed to file a complaint with an administrative agency and provide proof of such filing for a stay of arbitration. So the HUD administrative hearing, the complainant and the association will have an opportunity to conciliate, which really means settle the dispute during HUD's investigation of the matter. If HUD ultimately finds that there's reasonable cause, the case will go before an administrative law judge within 120 days, or either party may elect for the case to be heard by a federal district court. A HUD or DOJ decision not to proceed with a Fair Housing Act matter does not foreclose private plaintiffs from pursuing a private lawsuit. If the case is heard by the ALJ and the ALJ presiding over the case determines that discrimination occurred, the association can be ordered to compensate the complainant for actual damages, including humiliation, pain, and suffering, to provide injunctive or other equitable relief, for example, to make the housing available to the complainant, to pay the federal government a civil penalty to vindicate the public interest. The maximum penalties are $16,000 for a first violation, $65,000 for a third violation within 7 years, to pay reasonable attorney's fees and costs. Excuse me. In federal district court, within 20 days of HUD issuing a charge that it is found reasonable cause against the respondent, either party can elect to have the case decided in federal district court, as we mentioned before. Within 30 days of such election, the DOJ will file a suit and litigate on the complainant's behalf. The federal district court can order relief and award actual damages, attorney's fees, and costs. In addition, the court can award punitive damages. The complainant may, at their own expense, file a suit in federal district court within 2 years of an alleged violation, so long as the complainant has not signed a conciliation agreement and an ALJ has not begun an administrative hearing. The court may award actual and punitive damages and attorney's fees and costs. So as you can see, it could be costly for the association if there is a finding of discrimination. Cases of interest regarding director liability. In this particular case, the plaintiffs alleged that each and every member of the board was personally involved in each and every discriminatory action mentioned in their complaint, and that each member of the board personally intentionally discriminated against the families. In response, the board members filed a motion to dismiss, alleging that their actions were taken on behalf of the corporation and therefore they can't have individual liability. However, the court held that Chapter 617, which is our Not-for-Profit Corporations Act in this particular statutory section, does not protect against willful violations of rights protected by the Fair Housing Act, because the statute's immunity does not apply where the officer's breach his or her duties constitutes recklessness or an act or omission which was committed in bad faith or with malicious purpose or in a manner exhibiting wanton, willful disregard of human rights, safety, or property. So board members can be held liable for their own unlawful conduct under the Fair Housing Act. And it's clear that the Fair Housing Act allows for claims to be brought against individual defendants. So plaintiffs in this particular case had stated a sufficient claim against the board members, and the court denied the defendant's motion to dismiss on this issue. So it's important to note that directors can be held personally liable for discriminatory actions. There are some cases of interest here with regard to assistance animals, and we will discuss some. I just want to caution board members who want to rely heavily on this information, only because, you know, the facts that we're going to discuss were only discovered during this litigation process and really fleshed out. You may not get the opportunity to do that. And this is only done through the court system and not necessarily through an administrative procedure. So even though you may get some good information from this, always consult your association attorney before you take any steps with regard to assistance animals that may negatively impact the association. So in this case, Hahn v. Shoreline Towers Phase 1 Condominium Association, in January 2005, Hahn unsuccessfully lobbied the association for permission to keep his dog Booster as a pet. When he made the request, Hahn did not claim that he was physically or psychologically disabled. The year after his request for a pet was denied, he had the same dog certified as a service animal, and then claimed for the first time that he was disabled and needed a reasonable accommodation to keep Booster. For his alleged psychological disability, Hahn provided a letter stating that for a long time before he had been abused, kidnapped, robbed, and was assaulted by the stepson of a friend. He argued that if Booster was in his unit and an intruder entered, Booster would at least make him aware of an intruder, summon help, and bring him the phone upon command. Hahn provided 2 letters about Booster's resume and his various certification records. The manager sent Hahn a letter asking for additional information so the board could consider the request, and there was no response to that request. Then the general manager wrote a letter to the plaintiff asking again for documentation, including additional expert evidence under oath of the nature of the impairment, the manner in which it substantially limits one or more major life functions or activities, how the requested pet is necessary to afford you an equal opportunity to use and enjoy your dwelling, and if there are other corrective measures which would permit such use and enjoyment. And there was no response to that request. Hahn then filed a complaint with the Florida Commission on Human Relations, who found that there was cause to believe that the defendant discriminated against him by not providing a reasonable accommodation. Hahn then filed his lawsuit. So after having filed the lawsuit, then they found out this information. The psychologist opined that Hahn suffered from severe panic attacks. Dr. Evans wrote that Hahn was unable to properly cope with anxiety and stress, and that he was particularly vulnerable while residing at his home condo due to past occurrences on that property. He wrote that he was prescribing a service animal to provide support to help Hahn cope with his emotionally crippling disability, included a brief description of what specific tasks Booster was able to perform, giving hugs after a panic attack, what have you. Then there was another letter from a chiropractor who wrote that he was intimately familiar with Hahn's history and the functional limitations imposed by his disability. The chiropractor opined that Hahn had certain limitations regarding mobility and that a support animal would assist with his disability. Regarding the first letter from the psychologist, although the association could not have known this at the time, the record showed that at the time the doctor signed this one-page letter, his entire treatment of Hahn consisted of 2 recent 1-hour counseling sessions. During the second session, the plaintiff gave Dr. Evans the text or template for the letter that he wanted to be sent to Shoreline. That's the association. The doctor testified during the deposition that he had used much of what Hahn wrote, although he probably made some changes. As to the second letter, the court noted that the chiropractor had made no attempt to explain what Hahn's purported limitations and disabilities were. The record reflected at the time he signed the letter, the chiropractor, like the doctor, had seen Hahn only two times. He examined Hahn once several years earlier in 1999 and once in 2006, shortly before he had signed the letter to the board. For both visits, the chiropractor only performed examinations. He didn't give any treatment. And the chiropractor conceded at deposition that although he signed it, Hahn wrote the letter. Ultimately, the court concluded that the board did not deny the request, but rather it asked the plaintiff twice to provide additional documentation, which the plaintiff failed to do on both times. The board did not outright deny the plaintiff's request. It had held a meeting, put the issue on the agenda, and allowed Han to give a speech in support. Given the lack of information that they had, in light of the fact that the plaintiff had previously asked for permission to keep the same dog as a pet, no reasonable juror could conclude that the board knew that Han was disabled when it made the decision to deny his request. Therefore, the court held that the association did not act improperly by requesting additional information. Now, I also want to note that this was decided in 2009. Since then, as you've heard me say several times, HUD has issued new guidance when it comes to evaluating requests for an assistance animal. So, take that information with a grain of salt when you read these cases, and also know that there are administrative ways for complaints to be brought. In this other case, this was in 2012. The Mr. Benura is the name of the respondent here. His fiance resided at his townhome with her dog. The townhouse was located within the Sun Harbor community, which has a no dog policy. Letters sent to the association from the attorney provided that the animal was a registered service dog needed to assist his fiance with an unspecified disability. As there was no information received prior to the trial from medical professionals, 3 medical professionals testified at trial in support of the claim that the fiance should receive a reasonable accommodation from her therapy dog. There was a letter from a medical doctor testifying that he treated the fiance for injuries sustained as a result of an automobile accident and had lingering deficits in coordination and dexterity, and that he concluded she did not have any substantial limitation on any major life activity, which, as we know, because we know what a definition of a disability is, you need to establish a disability. A psychiatrist saw the fiance 4 times, and only after the lawsuit was filed, recommending the use of a therapy dog due to the fiance's ongoing depression and anxiety. That doctor also testified that the fiance's ongoing depression and anxiety was helped by the therapy dog on his personal observation on 2 occasions of her interacting with the dog. And a nurse and personal friend of the fiance found that the fiance's severe depression and extreme anxiety greatly improved as a result of the assistance animal, and made a similar recommendation to the court. Ultimately, the court held that the letters were insufficient. The court determined that the letters were insufficient and provided unclear explanations as to the nature and extent of the fiance's disability, such that the association could not conduct a meaningful review, and that the testimony from the medical professionals did not provide competent, substantial evidence indicating any substantial limitation on one or more of the fiance's major life activities, and failed to establish the necessity of the accommodation. Remember, we need to know that the person is disabled and has a disability-related need. There's got to be that nexus there. The court seems to suggest that a letter stating how the fiance is qualified, the limitations and difficulties she was suffering from, why she's entitled to the dog, or that the dog occupied the residence was necessary to afford the fiance an equal opportunity to use and enjoy a dwelling, would be sufficient evidence to require a reasonable accommodation for an assistance animal. This is another case here. The unit owner alleged that he was disabled with a physical impairment that substantially limits his ability to walk and maintain his balance, and that due to his handicap and related health conditions, he requires an assistance of a service animal. The unit owner made his initial request to reside with him to the association, and then the association requested additional information related to that request. In response to the association's request, the owner provided that the association's request for medical records was overbroad and in excess of what was necessary to make a determination to provide him with an accommodation. The association then acknowledged that the qualifications of the animals were not at issue, but reissued their request for medical information. The owner then delivered a doctor's letter to the association, which provided that the owner required the use of an assistance animal, and that the assistance animal helped him with balance to prevent falls, getting up after a fall, guiding him while walking, turning lights on and off, and contacting emergency medical services. A second letter from the doctor was also sent to the association, which additionally provided that no other assistance device, such as cane or walker, could provide this same assistance to McKay, the owner. The court ultimately found in McKay's favor. They determined that he sufficiently established that he is handicapped for the purposes of the Fair Housing Act and that the requested accommodation was necessary to afford him the opportunity to use and enjoy his dwelling upon the association's receipt of the initial doctor's letter. For a demand to be specific enough to trigger the duty to provide a reasonable accommodation, the defendant must have enough information to know of both the disability and desire for an accommodation, or circumstances must at least be sufficient to cause a reasonable defendant or association in this case to make appropriate inquiries about the possible need for an accommodation. So I hope you all were paying really close attention because you're getting quizzed now for our fair housing case studies. We're not going to do every single one of these case studies because these are actually plucked from our 2 hours. So some of them aren't going to be applicable here. So if I skip around, that's the reason why. So our first one here, an applicant with an obvious mobility impairment who regularly uses a walker to move around, asks her association to assign her a parking space near the entrance to the building instead of a space located in the part of the parking lot. Even though this doesn't have to do with animals, this is relevant because it's about having enough information to substantiate a disability. So here, can the association require the applicant to provide additional information about her disability? Hopefully you're all, I can't see any of you, but hopefully you're all shaking your head no here. She has an obvious mobility impairment, uses a walker. Thank you, Jeff. Thank you. So the association has reason to know that this person has a disability, a physical impairment that substantially limits her ability to walk. Can the association require the applicant to provide additional information regarding her need for the requested accommodation? Again, I hope you guys are shaking your head no, because it's obvious of the disability related need to have a parking space near to the entrance as opposed to far away, because she has a disability regarding her ability to walk. Okay, a rental applicant who uses a wheelchair advises the association that he wishes to keep an assistance dog in his unit, even though the provider has a no pets policy. The applicant's disability is readily apparent, but the need for an assistance animal is not obvious to the provider. Can the association ask the applicant to provide information about the disability related need for the dog? And here, I hope you guys are nodding yes, because the association is entitled to know that there's a disability related need for the animal. Excuse me. We're not going to go, I'm going to skip that one. I'm going to skip that one. Okay, here, because of his disability, an applicant with a hearing impairment needs to keep an assistance animal in his unit as a reasonable accommodation. Can the association charge an application fee? No, they cannot. Can the association charge a security deposit? No. An association cannot require the applicant to pay a fee or a security deposit as a condition of allowing the applicant to keep the assistance animal. However, if the assistance animal causes damage to the applicant's unit or the common areas, the association can charge the tenant for the cost for repairing the damage or take from a security deposit. If they have the right to have that security deposit. Here's another one. This one's not specific to an animal, but applies. An owner in the association makes an oral request that she be assigned a mailbox in a location that she can easily access because of a physical disability that limits her ability to reach and bend. The association would prefer that the owner make the accommodation request on a pre-printed form, but the owner fails to complete the form. Must the association consider the reasonable accommodation request even though the owner did not use the association's designated form? And yes, even though it's helpful for both the applicant and the association to have an application process, the association cannot require that the applicant fill out any particular forms in order to make that request. Let me see. No, I'm going to skip that one. I'm going to skip this one. Let's skip that one. I think that's gonna be it for us. Yep. So you guys are welcome to read those case studies on your own. But like I said, those were really plucked from our 2-hour course and not necessarily applicable here to our assistance animals. Thank you all so much. I will go through questions, but there are some administrative keeping things that you guys need to know. So I am going to flip it back over to Marielle and Jeff.
Thanks so much, Danielle. I do want to give everybody a chance to leave for the morning if they have to. You do not need to stay for the Q&A segment of this webinar in order to get your credits for the course. So thank you again, Danielle, but you guys did have a lot of questions, which is amazing. So if you want to stick around, we will start to go through them right now. Jeff, did you want to say anything before we get started with questions?
Yes. And Mary, thank you both. Danielle, excellent job. I know that was a struggle. I feel your pain. Our regulars know that I've been struggling with this as well, so it's going around. Excuse me. So before we get to the Q&A, you were, as Marielle mentioned, you're not required to stay for the Q&A portion to receive your credit. So before we get to the Q&A, I'm going to go over really quickly one more time on the evaluation and the certificate printing. So there's a link in the chat, and the link, when you click on it, takes you here to what you're seeing now. And fill it out. Oh, and at the top, you have the link to download the slides as well. So you can go ahead and click on that. Slides will open up. You can download them, save the link digitally, whatever you want to do. We'll keep the link active for the foreseeable future, so it won't go away. But then you go ahead and fill out the evaluation. And after you hit submit, you get a screen that looks like this, confirmation screen. It's got your name, course number, name of the course, the credit you're getting, instructor digital signature. You can then go ahead and right click and print it. You can take a screenshot with the keyboard, with the button on your keyboard that takes a screenshot, that sends it to your clipboard, and then you can paste it onto a blank Word document or a blank page on any of your favorite word processing documents and save it that way. Take a picture of it with your phone, print it that way. You got a few ways you can go ahead and do that and save your certificates. And then also on the evaluation, for those of you in the Q&A asking about knowing that you're here for your attendance and your CAM number, on the evaluation, when you click that you're a CAM, this opens up on the bottom and you enter your CAM license number, but if you're a board member, click on board member, and that part doesn't appear there. So it's an interactive form, and we'll get all the information we need for your certificates just by y'all properly filling out the form. So with that said, I will now turn it back over to Danielle and Marielle for the Q&A portion of today.
Jeff, it does seem like we have some people who wrote in that they don't see the evaluation, or
it's a link.
Trouble with the link. Okay.
I'll put the link into the chat once again, but also when people leave the webinar or when we end the webinar, a little window pops up with the link in it, and you click on the link. Perfect. And it takes you there. But I'm going to put it right now for any of our latecomers.
Right. And I know that you also send a follow-up email tomorrow with the slides from this presentation, as well as that evaluation form, in case you guys can't figure it out today or you don't have the time to play with it. Jeff will send an automated email tomorrow, just a follow-up, just in case as a backup. So
exactly. Same for y'all. Thank you for reminding me about that, Marielle. I failed to mention. We know some of you called in and are not seeing any of this. You're just listening. So there's no link for you to click on if you're calling in. So in addition to those of you having difficulty, the follow-up email will be sent to everybody who was here, whether you did the evaluation or not. So you don't need to do it twice, but you'll all get it. And it'll go to the email address you used when you registered for today's event. So keep that in mind. Be sure to check your spam folders. It'll be about 10 a.m. Eastern tomorrow morning that everybody receives that. It's all automated. Okay, back to you, Marielle and Danielle, for the Q&A.
Okay, so I'm looking here through some of the questions. a couple of the questions having to do with weight limitations in a 55 and older housing for older persons, or when a support animal that exceeds a weight limit is replaced, can you require that the replacement meet the new weight requirements? And the answers to the questions are no. It doesn't matter what the circumstances are surrounding the weight limitation, be it housing for older persons or a replacement animal. Whatever weight restrictions you impose are not going to be applicable to that particular animal. I know there's a question here from Norma about fraud in the service animals, or I'm sorry, emotional support animal arena. I'm sure fraud certainly exists out there, and it is very difficult to combat it, because right now, the way the Fair Housing Act laws are written, they very much favor the person with the animal. So if you have a documentation that you think is questionable, refer it to your attorney. Have your attorney take a look at it, provide you with advisement. At least then, in the event that you do make you do make a refusal or request additional information that might maybe tantamount to a disapproval, you have that to rely on. If I hit answer, Marielle, if I hit answer live, does that take the question away?
Yeah, I'll do that as you roll through. Don't worry about that. You
Okay.
just keep moving.
Okay. What forms are official for approval of comfort animals? I'm not entirely sure what that means. There is no prescribed form for the approval of assistance animals.
I bet you that question alludes to what you mentioned and what we briefly bantered about earlier, that you can get these fake things online, like on Amazon. I bet you that's a concern of this person. And how can an association combat that?
Well, when you receive those types of different certificates, there's usually not any information on there about a person's disability or disability related need for an animal. It'll say like, oh, this person is named as handler of this animal who is registered with whatever it is at this number. Typically, that information doesn't provide, that documentation doesn't provide anything concerning the person's disability or disability related need for the animal. At that point, you really need to ask yourself, okay, what do we know about this person? Do we know that this person is disabled? Do we know that this person has a disability related need for the assistance animal? And let that be your guide as to what information you can then reasonably request from that person concerning their disability and or disability related need for the assistance animal. Good morning. When an association asks for a doctor's letter for the service or therapy animal, can any doctor provide this letter? I think any doctor that is within their practice area can provide the letter. And again, when we're talking about medical letters that are substantiating the disability or disability related need, it doesn't have to be an MD. It can be a nurse practitioner. It can be a nurse. It can be a psychotherapist. It doesn't have to be a doctor per se. Our dogs say no dog, but understand they need to comply. Can a person take their emotional support dog into the pool area or walk along the seawall? So wherever the person is able to go, generally speaking, the assistance animal will be able to go with them. When it comes to pools, public health laws will keep the animal out of the pool itself, but the animal will be able to be within the pool area, like, by the lounge chairs or what have you. So yeah, the animal can go where the person is generally able to go. Are guests covered by? Yes, they are. They are covered by the Fair Housing Act. Is management of an animal regulating building required to allow access to guests? Yeah, guests would be covered too. Shouldn't animals be trained to be well behaved? Well, training is not required for a support animal under the Fair Housing Act. If we're talking about our service animals, well then, yeah. there is specific training that they need to have to complete a certain task or do work for that person's disability. Now, when it comes to good behavior of the animal, that you really need to have individualized evidence for that animal, and it would have to fall under the direct threat type of analysis to exclude the animal for their behavior. Can the association require that defecation be cleaned up? I think that when you're adopting rules and regulations, it's probably reasonable for the health, safety, and welfare of everyone else who's living within the community that the handler pick up the solid waste of the animal. But just know that there may be times where that disabled person cannot do that. If they have a mobility impairment or they're blind, they may not be able to do that. So the association may be in a position where it has to grant an accommodation to that particular rule or policy because of the person's disability and disability related need for it. If diabetes is considered a disability, would this qualify for an animal to be an emotional support animal? So remember, not only do we have to have a disability, but we also have to have a disability related need. There has to be a relationship, a connection, a nexus between the need for the animal and that person's disability. If the person's disability is they're a diabetic and they need an emotional support animal, there's really, to me, no nexus between the two based on that scant information. There are dogs that are trained service animals for diabetics. Sometimes you may see them like in a little pouch in front. They're trained to smell the breath and can determine the blood sugar levels of someone by smelling their breath. So if that were the type of animal being requested for someone whose disability is based off of diabetes, well, then I would see a disability related need there. But if someone has diabetes and they're requesting an emotional support animal, I think in that circumstance, it would be reasonable for the association to say, okay, you have a disability, you're asking for emotional support animal, please provide us with a little bit more information regarding the disability, the emotional disability, excuse me, or, the disability related need for that particular animal, I think would be reasonable there. Is the pool area governed by okay. So when we talked about the pool area, the dog can be in the pool, health laws would prohibit it. If an individual uses an out-of-state health provider and has one or more Zoom consultations with the telehealth provider, does that constitute providing in-person care or services on at least one occasion under the Florida law? Okay, so telehealth, when you're actually reading the law, oh, hi, Barry. I just read the name. Okay, so when you're looking at that particular Florida law, there are kind of like three buckets of the different healthcare providers, right? That second bucket being a telehealth provider. And I touched on this before. Telehealth providers, there's a certain license certification. Again, I'm no expert on the regulations governing medical healthcare providers, but that second bucket is the telehealth. And if they're a telehealth provider, I don't think it matters what state they are a doctor in, so long as they're a registered telehealth provider here in the state of Florida. So if I'm sitting in Florida talking to a licensed telehealth provider who has their health practitioner's license from a different state, that I think would be sufficient under the Florida law. If I am talking to someone, a California, wherever state licensed doctor who's not telehealth, I think in that circumstance, I would have had to have seen that doctor in person. I don't know that seeing them via Zoom constitutes in person, because that to me would have to fall under a telehealth provider. Again, this is me giving you my impression. This isn't legal advice. I don't know for sure. There's really not enough guidance here in that regard. And providing it on one occasion versus the number, of having provided over years of treatment. We have some guidance provided by the cases, but again, those cases are old. they're not post the HUD guidance issued in January 2020. So it's really difficult for me to say, well, this many times is sufficient. There's really no bright line rule here. All of these things, when it comes to the Fair Housing Act, you'll see it's a case-by-case determination, and you really have to evaluate each situation on its own. So,
we've reached our advertised time, so let's just take a couple more questions. And there's one I'd like to read because it seems like most everybody's question is about service animals, and I found one that's about a pet. So let's address one that's a little bit different.
okay.
Can an association charge a higher fee depending on the size or weight of an animal that's not a service animal or an assisted animal, just regular pets? So can they charge fees for pets based on weight and size? Have you heard of it? Have you seen it done?
I haven't heard of it. I don't know that. I think so long as you have a legitimate business reason for doing so, maybe. I've never researched it. Maybe. The answer is maybe there. Yeah, I mean, I don't see why not. So long as it's reasonable, there's a legitimate business interest for doing so. I suppose you could. Yeah, no good answer on that.
Yeah, no, yeah. Sorry, didn't mean to stump you.
No. It's a good.
Welcome to Stump the Attorney.
It's a fair question. But ultimately, we have to base ourselves in reasonableness. And if it's reasonable to do so, then potentially, I have not done any research or know of any particular cases which would absolutely put it outside of the realm of reasonableness. How about that?
Okay. Let's do a couple more, if that's okay.
Sure,
with you.
sure.
Is that okay?
So I like this question from Harry Cohen. If no pets are allowed, how many ESAs are allowed? And it kind of relates to Sherry's question here. Can a resident claim a need for multiple ESA animals, i.e. 2 dogs? So yeah, they can. And there's a particular Florida law which discusses this. You can have more than one assistance animal. And the Florida law provides that each animal has to serve a disability related need, is essentially what it is there.
Okay.
If ESA continuously violates building rules, can we disapprove renewal of a lease? I'm going to avoid this question. Ask your attorney. Because this is really more so when it comes to lease disapprovals and sale disapprovals. That's really a different realm than necessarily only assistance animals. Addressing the assistance animal rule issue, does the assistance animal present a direct threat? Is there a need for the assistance or of the person, the disabled person, to have an accommodation to whatever that particular rule is? There are just so many different factors that go into answering a question like that you really need to talk to your attorney. So I didn't mean to be flippant in my response, but that's the reason why, is that there are just so many different things that go into that answering that type of question.
Okay. Let's do, if it's cool, there's one person that and so if you can pull up on your side there on your notes, FFHA case study number 5 that you went over. This person is asking for a clarification of something, and we'll use this as our last question. We know we're now 5 minutes past our time and people want to get ready for lunch here. So we know our attendees want to get ready for lunch. So I apologize, as I must have missed something in the FFHA case study number 5. Why can't an application fee be charged unless the applicant is already a resident? Does that make sense?
Okay. We may be talking about 2 different things. So if your association has the authority to approve transfers or to approve leases, and there's an application fee tied to that, that's different than charging a fee for the application regarding an assistance animal. So you can't have a separate fee for making application for a reasonable accommodation to the association's pet prohibition, pet restriction. But that doesn't have to do with, you know, your application for transfer or lease. Okay, so that may be the difference there for you.
Okay. Okay. Marielle, I'm going to turn it over to you in just a second for closing comments for you and Danielle. One question I want to address that has popped up here several times that doesn't require an attorney opinion or answer. Can I send your slides to all owners to avoid any misunderstanding concerning this subject? And the answer is what Danielle mentioned earlier. None of this should be considered legal advice. Feel free to download and save the slides, distribute. But again, if you're unsure about anything, you should really be contacting your association counsel. The slides, the commentary today, it's all for educational and reference purposes. This should not be considered official legal advice. Is that correct, Danielle?
Mm-hmm. Yep.
Okay. Ladies, back to you. I will shut up and hide myself.
All right. Let me see. When it comes to, I'm looking at a question here from Linda about the building being no pets. They're housing for older persons, 55 and older. One owner who lives here for over 5 years got a dog. Our president told her it was okay. Can the owners in our building ask her for a reason for the pet? So I would say that there's nothing that prohibits someone from asking why you have a pet. Or why you have the animal, let's say. And that really doesn't necessarily involve the association. I will caution that there is such thing out there as hostile environment discrimination. If things become discriminatory between the two, then the association may have an obligation to step in. But as far as owner to owner, resident to resident questions, there's really not much, you know, there's no real prohibition there of asking them the question.
Why don't we pick maybe one more if you'd like?
Okay.
Right,
Okay.
wrap it up.
I'm going to try to make it a good one.
Okay, make it a good one. Just want to be respectful of your time.
Okay. I think I may not have touched on this. I don't know. Do we have right to see the vaccination status of an animal or require it to be licensed with a tag from the county? Yes. Yes, you do. You can require that the animal be vaccinated and be licensed. There is a Florida statute on point there as well. So anyway, thank you guys so much for coming. Thank you for having me, TSK. You know, you can always go to our website, kbrlegal.com, if you'd like more information about our law firm. We do have some really great resources there and an events calendar. And, you know, I'm here if you have any questions.
Thank you so much, Danielle. You did such a great job, and thanks for all your time answering questions. We really
Not a
appreciate
problem. My
it. Such an
pleasure.
interesting topic, so much to know, so much to ask. So we appreciate it.